Yes.
Lord, may I make a very humble prayer, my Lord? Contempt applications are pending for quite some time. One day,
Will. Don't worry. We'll sit together.
because it's the last item, my Lord.
Let us see.
Kindly, my
We
Lord.
are taking up the whole of the week.
I
We are
know.
taking up
I know.
applications. Don't worry.
If possible, my Lord, some Friday or something, so that
Don't
because
worry.
they are emboldened, they are not doing anything.
Let us see. Let us see.
Lord,
We'll do it.
Lord, I'm grateful.
I am for the appellant, my lord. The learned advocate has appeared before the lordship.
Where?
Communicated, my lord, to him personally and also to the state. Not here appeared.
Yes. Hey. Mute করে দাও applications. बाकी ये तो अच्छे
Your Lordship, in this matter,
73. Yes,
Your Lordship, in this matter, I am seeking a day's accommodation on behalf of the
yes.
council.
One of the member of the bar has shown
Your Lordship, I'm
client says every time coming that the matter is in the list and what are you doing, sir?
Your Lordship,
This application, why you don't?
Your Lordship, I am not brief in this matter. The advocate and record and
Leave the matter go out of place. Whenever your counsel thinks that he is ready with the matter, they will mention.
Mr. Anyuddha Chatterjee is for
Maybe
one day. Your
it's not
Lordship.
there. So let this go out of it.
For,
Not necessarily, we will not keep those matter listed.
for one day, Your Lordship.
Not-
The council is not for personal difficulty. He is not in the court, and the advocate on record. Grateful to Your Lordship. 74 above the petition.
What is this application, sir? It's a
Section 5, my lord, probably be
it's a
confidential
matrimonial.
matrimonial.
Okay.
Lordship, I am for the respondent led by learned advocate Mr. Sabyasachi Mukherjee. Lordship, I am praying for only 2 days accommodation, Lordship.
Who is for the appellate? 275. Where is Miss Madhumanti Das? Madhumanti Das.
275, my lord.
You are for
I am for the appellant, my lord.
appellate. Is the matrimonial appears.
Your lordship, we can not today, my lord. Yes.
Yes, next.
Yes, my lord, I beg to appear on. My lord, there was a section. Sub the,
Yes, have you served the
Yes, my lord, I have
substituted
served.
respondents?
I'm
You are
appealing.
appearing for the substitute. What is the suit for?
my lord, will, my lord, was probated.
Will was probated.
Probated.
You were a objector?
Yes, my lord, we have not been cited there. We had no knowledge about that. When a writ petition was moved before this honorable court in the year 2020,
Why writ petition?
because for the new electricity connection,
Oh.
then we have been added as a private respondent. Then we came to know before the court that there was a will and that has been probated.
So what is this application is condonation?
Yes, section.
It has to be done first. How many days delay?
My lord, admittedly 156776 days delay. 1576 days delay. Lord, 2019, Lord, we did not have any knowledge for such reason. Delay, we have explained.
Have you taken any other steps than the present appeal?
No, no 263. They have directly come before your lordship. And paper publication was made. It was made, but they have not taken the recourse or revocation. Then how can they come before your lordship? How
Lord,
can they prove
I
their
cannot-
case, lordship? No evidence.
File your opposition. Long delay.
Yes, Lord, admitted. No, I cannot deny it.
Opposition within 2 weeks. Reply 1 week. Matter to appear after 3 weeks.
I'm great.
Next. Matrimonial.
For one of the
Partition suit.
Partition suit lawsuit against the preliminary degree. Can 1 is section 5, delay 61 days. Whatever.
58 days delay.
61 days delay.
Anyhow, our stamp reporter says 52 days. 52.
Lots.
Yes, what do you say?
only
52
I'm appealing for
52
one
days
of the
delay.
one of the respondent. I'm not for all.
Otherwise, complete the service, file every service. As per lordship's direction, I go.
Yes, to the addressee. To the addressee. To the addressee. R. Dotto. Addressee. 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 C. Oscar.
Only one, the performer defendant.
T. Page.
The copy টা if you say copy লিখে copy লিখে JS copy আছে না
Aloka. Who is Aloka Sardar?
yes, performer defendant number 9.
He is with you.
Yes.
You were the co-defendants.
Co-defendant.
Who is Kalipodo Noskor?
Kalpana Noskor.
Kalipodo Noskor.
Loss it is auto possibilities.
Sir, this
Wrong.
is the postal receipt. Says Kalipodo Noskor. Kalipada. That
Yes,
that
yes.
pronounced Kalipodo.
Loss as per memorandum of Srimati Kalpana Noskor.
But then you have not addressed to a Kalpana. Who is she? Proforma or not proforma?
Performer.
She is also proforma. She contested in the trial court or
No,
not?
no contest.
পুলিনের খালি এই দুজনই আছে না? পুলিনের কারা? এখান থেকে কস্ট টাইটেল
The
No.
trial court.
Only 1, 2 to 3 contest.
And they are the appellant.
They are the appellant.
So what do you say?
No, 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 I'm not on the limitation point, but
So
only thing
limitation,
that-
let it be allowed.
only thing that paragraph number 3,
What?
that they have made an averment,
Paragraph?
number 3. Now let's see, they have taken a reference of a title suit in paragraph number 3 at the bottom.
Yes.
Look, this suit is dismissed for default, my lord, as per my instruction from my counterpart. My lord,
Before or after reformation?
before
Lordship, as per
my instruction, my lord.
as per my instruction, Lordship, that was I have heard. And also in the deposition, PW1 deposed
This is
to
the
that
study
extent.
Order, server copy of the order.
Deposition of the PW deposed,
How
that
it is material?
Very well, my lord. In the, my lord, after condoning the delay, my lord, in the step, my lord, I need to take this point there.
Whatever. So how it is material?
No, my lord, not material, but
And this is the partition suit
partition
partition.
and preliminary decree or final
Preliminary
preliminary.
preliminary.
Yes.
The judgments are against you.
No knowledge.
Can one.
Heard, my lord. On the last occasion, I heard from just
Now,
Tandon that Supreme Courts nowadays are not even condoning 1 day's delay. Is not condoning 1 day's delay, Honorable Supreme Court. In a,
What?
in a matter, my lord, just my lord said recently Supreme Court has passed an order not condoning even 1 day's delay.
No, that the recent judgment is that the previous judgments are that a meritorious matter should not be dismissed on the anvil of the limitation. The court should encourage the litigation to be decided on merit. If there is some explanation, that the court should take a lenient view and then decide. Recently, the court says that meritorious matter cannot be a sole ground for that. The court has to apply, and here he has said no legal knowledge, which is not a correct proposition. There are a judgment which says that cannot. Ignorance of law is not an excuse at all. Why you make those affirmations?
There is a
Is passed by the trial court holding their share in the property.
Yes.
If their title suit fails, then at least the preliminary decree has declared certain semblance of undivided right, title, and interest.
Yes.
So let the partition
But
commission
there is
work.
other party, Milord Nobo Kumar, Milord, who they now brought to Milord in this preliminary decree try to assert. Nobo Kumar, if comes in, Milord,
We will not, that will be decided in the appeal, sir.
absolutely, Milord. Today, Milord, if the suit by Nobo Kumar, Milord, which is stands dismissed for default,
That will
Milord,
be a merit,
on merit.
on merit. We are not. We are simply staying so far as the final decree. The final decree is passed, then what will remain?
Absolutely, I bow down. But if
Sorry.
on merit, Milord, if I can satisfy Milord, he has nothing. Milord, today, because his claim is entirely based on Nobo Kumar, Milord, whose right share has not been declared, and the suit which they referred to, Milord, is dismissed now.
But now in the preliminary decree, his share has been declared.
From Bhupendra.
Whatever.
But he is bringing now the. But that's
Will
the
consider-
exactly point of appeal.
No, we'll
That's
consider
exactly
that.
the point of appeal.
That we'll consider that at the time of hearing. We'll consider it. No. Yes, that order that the preliminary, the should be retained by the court so that it may not get hampered. And then it will send all the records. No difficulty.
No, kindly expedite
They will
the hearing of the appeal, Milord.
Absolutely, we are saying. You take a responsibility of Paperbook of bringing the lower court record.
I shall.
Tell it. Plaintiff respondent will file the special messenger cost, prepare the Paperbook within 4 weeks from the date of notice of arrival or record. Liberty to mention further. Call the next. Stay no. Only the no final degree shall be passed pending.
I pay for the respondent.
Where is Mr. Sorbanando Sanyal?
I am appearing for the appellant.
Oh,
Lord, in this matter, my lord, we have taken out an application for addition of party being can
3 applications are there.
This is evidence service.
Section 5. Can 2 is the section 5.
Can 1 is stay.
Alimony pendentility. Alimony pendentility.
Alimony pendentility, it's a matrimonial.
Matrimony.
Addition of party.
The application after the
Whole week we'll take up. Don't worry.
grateful. Grateful. My lord, I am the appellant, my lord. I'm praying for 2 weeks time because my lord is already reacted to Savapal and advocate.
The
Other-
service is not complete.
Num-
Let
not-
this matter go out of list
My lord,
with liberty to mention. Go, go, go. Yes, next.
For the respondent 1, 2, and 4, and I am led by Jyoti Prakash Chatterjee. He is sick, my lord.
Lordship, on the last occasion, your Lordship was minded to direct affidavit in opposition to be filed on the
Has he
Lordship.
reply?
They have not filed,
They have not filed.
not sir.
Taking a personal,
Lordship, I agree.
not today. He is here. Next.
Lordship, I am for the appellant, Your Lordship. I am led by Mr. Rahul Gormakal, Your Lordship. He's on his legs on court number 22, Your Lordship.
What is this application?
Your
Three
Lordship, this is there are 3 applications, Your Lordship. Can 1 is for injunction, Your Lordship. Can 2 is for condonation of delay.
Let us see condonation first, unless it is condoned. Have you served the copy?
Your Lordship. Your Lordship, I believe they had already appeared in the earlier occasion, Your Lordship. Your Lordship had also passed an
But
Injunction
there
order.
was a direction that the appeal and application both to be listed. But why the application is listed?
Your Lordship. And
এই, তোমরা চোখ বন্ধ করে করো। Under the heading for order,
I appear for the respondent number 1 to 3.
is for the appellant. What is this application for?
application
Four
for
applications.
3 application, my lord, now pending before your lordship.
There
uh,
can 1 to
section
can
5.
4.
Section 5, condonation of delay and setting aside abatement.
Condonation of
See.
delay of
Of my lord, condonation, section 5.
section 5 of setting aside amendment or appeal.
Setting aside amendment in my lord condoning of delay, condonation of delay.
Yes.
Only
much
my lord
days
8,
delay?
8, 9, 11 has not been served, my lord. Other respondent were served.
Who are they?
I appear for respondent number 1 to 3.
1, 2, 3.
8, 9, 11. Why? Who are they?
They are my lord the defendant. Defendant,
You were also defendant.
I am for the plaintiff respondent.
Why they have not been served?
9 has
Instructions are that we cannot appear for them.
I have to
He appeared.
No, no, this 8, 9 and 11.
তোমার কাছে memo
Raj. This is actually against the review, rejection, allowing the review application.
For the appellant, my lord. My lord, respondent number 9, defendant number 9, my lord, has died, my lord. I file an application for substitution.
When he died,
2 days ago, my lord.
when he died,
Few days ago, my lord, 2 weeks before.
have you taken out application?
No, my lord.
It is submitted by the counsel for the appellant that the respondent number 1 has died.
Respondent number 9, my lord.
Respondent number 9 has died during the pendency of the instant appeal and prays for an accommodation.
Good.
Next.
I beg to appeal the respondent. Appeal the respondent.
Partition,
No. The probate proceedings,
probate, yes.
they have already inspected the will. The statement was filed, issues are framed and posted for final hearing. I have submitted the evidence. They have started their cross-examination. Next day, 10th May, but further cross-examination. Now they want to challenge the order passed on 14th September 2023.
What? What is that order?
Order that is the probate petition is not in proper form and they wanted to get a certified copy of the will. In spite of that, they inspected the will.
Section 5 is there,
Section
out of
5,
time.
Condition of delay.
Where is Mr. Sopon Kumar Pal?
Section
6 days.
But the so far as the
6 days.
let the matter be expedited for direction by the trial court.
Not be. Next.
Yeah, Lordship, can indulge this, there be a direction to for disposal of the probate proceedings.
Madam, in this matter, I am for the appellant, my lord. My lord, I am challenging the order dated
Order? This is the first appeal.
August 2020.
Judgment.
Senior division.
Where is the affidavit of service?
My lord, I appear for the respondent number 1, defendant in the suit for partition, preliminary decree dismissed on the ground that he has failed to prove any right title and interest in the property.
So only thing is to expedite the matter and
My lord, I am resisting the injunction application because, my lord, he has failed to show his right title and interest, 1. And number 2, my lord, there was no order of injunction before the learned trial court also.
what happened? You should file your opposition.
Yes, my lord, I'll file an opposition. Kindly,
Opposition by 2 weeks, reply 1 week, matter to appear after 3 weeks. Next. No. Next. Let's call the next. Partition suit.
No, Lordship, probate proceeding, Lordship.
Wait.
Lordship was directed to serve the copy. I served the copy. Respondent number 4 received and 1, 2, 3 refused.
Refused.
Lordship.
The good service. Anybody appearing? What is the application for?
Application not to create any third party interest. Also, Lordship was passed an order.
Probate has been granted or not?
No, dismiss.
Why? On what ground?
Twofold ground, Lordship. petitioner failed to produce the certified copy of the will,
Certified copy of the will. The original will.
register will. Register will at the time of
So, the original will was there.
true copy or marked exhibit.
True copy was
Was
marked.
marked exhibit at the time of filing of the plaint. He annexed the certified copy of the will, but certified copy of original just lost. The certified copy is no marked on one of the grounds. Second
But the
ground
true copy was marked without objection or
with objection.
With
With
objection.
objection. Another ground, lordship, petitioner without comply the section 68, he can take
No
record
attesting witness.
three attesting witness. Respond number
No
one
attesting witness was brought.
brought. They are after summoning, they are not come before this court. Three married daughter, three married daughter is a attesting witness. Respond number 1 to 3.
Let the affidavit of service filed to yes. Next.
Lord's my appeal. My lord, by the last order, my lord had rejected a preliminary objection that the respondent had raised, my lord. By the detailed order, their objection was on maintainability, was yes, was no. Now, my lord, we have filed compilation of documents, my lord.
Appeal has been admitted.
Yes, my lord. List of it.
What is the matter about?
My lord, this, my lord, I am a
There are certain documents, my lord.
16 to 9. Yes.
my lord, very briefly, my lord, I'll indicate, my lord, the background. But I am a decree.
Documents which have been included in the paper book.
Which are not there in the trial court.
No.
Some documents are not part of the trial court. Some of which have come into our possession after the decree has been passed, my lord. So, my lord, we my lord,
Well, in fact, my lord, I shall just remind your lordship, on the 21st of March 2024, when this matter appeared in your lordship's court, the lordship was pleased to pass an order on the basis of the accommodation which was sought for at that time. It was pointed out to the learned advocate, my lord, who was a junior. In fact, I was sitting there, your lordship wanted me to assist him also, as to how to prepare a paper book, my lord, after it is being admitted. And my lord, chapter 9 was referred to by your lordship, and your lordship was pleased to point out that you look into it, and thereafter you prepare the paper book. My lord, thereafter, my lord, it doesn't seem that anything has been done on that.
We do not have any inclination to read those provisions of the appetite rules. So that is what is an irony. So I think it is also a collective senior also as well as because they must
I'm sure, my lord, my
spread those ideas into them that at least when you are practicing as an advocate and record of the court, you should at least know the appetite rules and the procedural aspect.
No, my lord, I mean, we always learn. Every day we are learning. Today also I am learning.
Me also.
Yes.
Every
But
day,
then, my lord, it seems one of the paper book which has been prepared, your lordship will have some problem, my lord, when your lordship hears the matter. Because there are some papers which have been included. There are
my lord,
some
may I only indicate this? There are some documents which, my lord, have come to the possession of the applicant, my lord, after the decree was passed. And an application ought to have been made.
Aware of order 41.
My lord, be aware of that, my lord.
Aware, then can you include?
My lord, in fact, my lord, I have also prepared an application. It's ready, my lord.
I don't know, but such papers in the paper. Even the appetite rule says that while preparing the paper book, any document which were tendered in evidence but was
Not exhibited.
marked exhibit should not form part of that.
I bow down, my lord. That's a my lord, because these documents are extremely crucial, perhaps will be necessary, my lord.
Unless the court decides to take that documents as an additional evidence report.
Yes, my lord. My lord, what we were, my lord, contemplating is that we would press the appeal, and in course of it,
Let the senior counsel have pointed out to your junior that this cannot be done in this fashion. Then why he has done that? Why he has done that?
Lord,
my lord, in that event,
kindly see, my lord, paragraph 39 of the stay application, their own stay application. Kindly, my lord, look into it. Kindly see that. And I think this is the correct approach. Kindly look into paragraph 39 at page 19. Page 19, para 39.
may I humbly submit this, my lord? My lord, kindly permit me to file this application, which is ready.
These are the statutory provisions that
Yes,
right we have to take care of. Why
Because, my lord,
team of the court is required
Yes.
for that purpose.
my lord, was my lord, the endeavor would have been, my lord, to present the appeal, and in the course of hearing, if my lord was of the view that these documents are necessary, my lord, under order 41 rule 27p and bb, my lord.
We don't remember that what we observed orally.
No, my lord. But I'm saying if course of hearing of the appeal, if it commences to my lord that the documents are necessary to deliver the judgment, or my lord it's for substantial cause, my lord, then my lord will permit me to use an application.
It will not permit you, sir. It is up to
Then
you.
my lord, in that way, my lord, may
You
kindly, my lord, in that way,
conscious that you'll have to.
my lord, may I humbly pray for a short adjournment so that I can move this application, which is ready and affirmed, my lord. Because my lord, these documents would be necessary when my lord, the appeal is moved.
Papers should be taken off from the paper book.
If
Those very documents which my learned friend wants to include under my lord order 21 rule 47.
if my application is allowed, perhaps that will not be required to be removed. If my application is allowed, then perhaps this paper book will not be required to be changed, my lord. If it is rejected, my lord, then perhaps I will have to change the paper book.
Get your junior to point out those papers.
My lord, we are aware of those. In fact, we
Just to point out the case numbers and all, we will not take into account those. Otherwise, returning the paper book and to be filed afresh, you know that the amount of cost.
in fact, my lord, in the index, my lord, the objection has been indicated, my lord. So the documents which there are seven to eight documents which perhaps is not part of the trial court records, but others are there, not in dispute, my lord. Those 7 documents for the time being, my lord, will not look into, my lord. And then, my lord, in fact, these are, my lord, documents which are emanating from their end, my lord.
Rely upon the document, don't worry.
And my only difficulty when I'm led by Mr. Mukherjee, I mean, he intends to rely on those documents, and this is in fact very crucial, my lord, very important documents, my lord. And we'll be able to persuade this honorable court, my lord, to understand, my lord, this we're really, my lord, handicapped in not using it. Mr. S.N. Mukherjee is appearing, my lord, is leading me in the matter, my lord. Mr.
There are 2 S.N. Mukherjees, both are senior.
Junior Mr. Mukherjee.
Yes,
No,
Yes, madam.
I address him as Gopal Mukherjee, but I think that easier to.
My lord, my lord, for convenience, my lord, I have prepared.
If they are so important documents, why is it, my lord, they were not relied upon in the trial court, my lord?
That's what we'll explain in the application, my lord.
Has to come under by
From them.
So some documents have come into in our possession in 2019. The decree is of 2010, my lord. I'm a decree holder.
FMAG is originating from an execution proceeding.
Yes, my lord.
Yeah.
My learned friend has
Order 21 rule 97. Order 21 rule 97.
Third party.
third party.
Yes, the decree had been passed against a person who is not a party to the proceedings.
And it's our case that they are all same, part of the same group, my lord, same entities, my lord. And there are documents to show that the directors are common, the partners are common, and it's a,
Sought on behalf of the applicant.
my lord, I can,
Take an appropriate steps in the matter. If there will be a direction for affidavits, we will get an opportunity.
My lord, we are just a bit confused about the paperwork. So I think I should talk to my lord.
Paperbook is part one and part two. Exhibits in part two, that is how we keep the feedback. I find that the rectification of documents in three places. These are very important. I think we appreciate. But that should also be taken care of while filing an application and making an annexures. We find in the annexures the same documents find place in 5 places. 5 places. Getting 3 places. Taking a voluminous. And my view is still more, I would say it is supported. The more voluminous the cost paper, less legal cost it comes. The filing of regular paper of all things. We can inform us with a bigger difficulty nowadays is because there is no mechanism in the court to prepare a formal paper. Formal, what is the problem? Now there was compilation persons who were doing it. But now what it is there. A lot of problems preparing a formal paper. There are, we have adopted an informal. It is left in the hands of the member of the bar.
जज इसलिए adjourn कर, तुम चाहे start, तुम चाहे rely मत करो, आगे करो. He says you can't make this part of the
next one. Go to the next part, right?
My lord, I am appearing on behalf of the respondent.
This application can fall into.
This is a continuation application where there was a direction to file affidavits. Section 5. My lord.
Length of delay.
My lord, the length is around 10 years, my lord. My lord, we have exchanged affidavits.
My lord, I am led by Mr. Siva Prasad Mukherjee, my lord. I am praying for not today, my lord.
Why? Why you are asking for an adjournment?
He is in some personal discussion.
My lord, I am also led by Mr. Aniruddha Chatterjee, my lord. He is not in town, my lord, if this could be.
Both of you are not ready.
My lord, my opposition is ready. Only a day's accommodation, my lord. Tomorrow I'll do the matter, my lord.
My lord, tomorrow is okay with us.
Oh, because we proceed that.
My lord, we understand.
Unless we exhaust, we cannot come back. And you know that this week we have fixed for the applications.
My lord, I understand.
It shows that both of you are not interested. Let's file that affidavit of opposition and filed by the respective partners on the joint prayer. Let this matter appear after the vote.
My lord.
Deeply okay.
Please, your lordship, for the appellant. My husband, before your lordship, my lord, did you issue a marriage?
Probate or partition?
Partition, my lord. Pursuant to your lordship direction, I have served copy, my lord. The plaintiffs have received. March
What is the service affected? or not affected?
plaintiff.
Yes.
Plaintiff have received.
What about others?
No, they are on my side, defendants, pro forma respondents. My lord, kindly see your lordship's order dated 21st March 2024. My lord, the learned trial judge, my lord, had asked my counterpart in the trial court, my lord, to seek some clarification.
What clarification?
My lord, kindly see the second page of the order. First, we dispose of the instant appeal.
Yes.
Yes, we dispose of the instant appeal.
What?
My lord, that would have been, we dispose of the instant that. And secondly, my lord, kindly see the learned trial judge, my lord, is confused.
Application.
That is also not a disposed of. Kindly see the last line. The appellant is directed to serve the copy of the instant application. The learned trial judge asked my learned counterpart in the trial court, then what is the stage, whether I should proceed or item delivered, confirmed.
Then what application is appearing today?
My lord, this is my lord application for stay, my lord. Lordship had passed, my lord, 3 directions, my lord. The final decree may not be drawn up till disposal of the appeal.
The Where?
Part one constituency. Part one constituency.
You will be going there.
Yes. I will go in there. Then instead of 13, can it be 16? 16. 16.
That owner matter, not this one.
At 291. 290. Deep development.
My lord, in this matter, my lord, the advocate on record's mother has expired, my lord. I am praying for, my lord, Devdatta Basu, my lord. The advocate on record, he's
Submitted by the valid advocate.
Suit for defamation.
For
Defamation.
libel or slander.
Slanderers.
Yes. Slender or libel. What?
Lordship, this is slander.
Slender. What he has spoken and what he has written.
Lordship, before going to the Lordship's order, Lordship, a case was started at the instance of the appellant, and FIR was started in a non-bailable and cognizable offense.
Malicious prosecution.
Malicious prosecution. Now,
Not a defamation or slander or libel.
now this suit has been filed as a defamatory suit. Lordship, kindly,
Both malicious prosecution also.
Lordship. Now, Lordship, in the criminal proceeding, Lordship, the proceeding was initiated at the instance of the prosecution. Charge sheet was filed, cognizance taken, ultimately trial.
But he must be a de facto complainant.
Now, Lordship, here, Lordship, my present ground is, Lordship, the entire criminal proceeding has been initiated at the instance of the state. I am only the informant that the incident happened. But state is not a, Lordship, the party.
When the proceeding ended,
Lordship, the proceeding was ended 11th May 2017 by declaring
when the suit is filed,
the suit was filed which was 2017. Money suit 530 of 27.
the limitation on malicious prosecution of 1 year. That's why I asked this question.
Within time. Now, Lordship, my first,
Serve the copy.
Lordship, I am facing the Lordship, the execution, Lordship, the
Pay the execution, serve and come back.
Lordship, for the time being, let there be a stay for a limited period because
You have to deposit, show your bonus.
Lordship, palpably wrong because state is not a party in the suit.
The 41 rule by money difference. To serve short notice, returnable on 14th. Yes. 7th May. 7th May with the execution.
Lordship, 7th May is the date of execution in the court below, Lordship. That is.
6 steps in.
So let the LCR be called for otherwise.
Let the trial court record be called for.
At least, Lordship.
Execution proceeding case record will not come. That will be proceeded.
Zero. Well, Lordship, my client is ready to willing deposit the amounts.
Come after, but you come. That can be done in the execution case also. Yes.
I appear for the plaintiff appellant. Your lordship was pleased to admit the appeal. Considering the fact, my lord, our suit was
for declaration that an oral contract is binding upon the parties. The learned trial court has refused the ad interim order of injunction on this court that there was no concluded contract. But my lord, relying on page 22 of my application, where there is a specific admission of my plaint case, your lordship was pleased to admit the appeal. Your lordship would kindly take page 22 once. My lord, this is the letter that was being issued by my client to Reena De. And
From Reena De to.
from Reena De to my client. Reena De happens to be the legal heir of his brother, Shukesh Chandra Sengupta, with whom I had entered into an oral agreement for transfer of property way back in the year 1981. And the consideration was rupees 15 lakhs. And that admitted consideration, they have admitted the they had admitted this consideration amount. They had admitted the agreement. To that agreement, my lord, he had sought for transfer of the property, my lord. That was also done. Kindly takes the last paragraph one. Now, my lord, kindly takes the order impugned once. The order impugned এতে annexed কত কত আমি আমার একটু মার্ক করা that there is threat. মার্কটা যেটা এখানে annex করা আমার প্রিন্টটা আগে তো দেওয়া হয়েছে তারপর Now kindly takes my plaint once. What was my plaint case? And
It was a 1 rupee coin or 1
Yes.
rupee coin of the British government.
yes, and section 10 of the Indian Contract Act, my lord, oral contract, my lord, in furtherance to that, my lord, she has admitted that there was a contract.
That we have seen. The only thing is she has said no consideration, no concluded contract.
No, she has said on the valuation part. She has said that 1981 it was 15 lakhs. Now today the valuation should be much higher than that. Kindly takes page 23 once.
She said no consideration,
No, kindly
no
take.
contract.
My lord would kindly takes page 22 once.
Please read that, the next page of that letter. There is no consideration, no contract. Last line of that any paragraph.
Yes, my lord. The agreement was unenforceable because no consideration, no contract. But however, yes, but preceding that paragraph, he has said that after the lapse of so many years,
Has admitted 1 rupee British.
and the actual consideration was rupees 15 lakh.
Has said no consideration, no contract.
But she has admitted so as to the consideration of rupees 15 lakhs. Kindly takes the
That is the consideration. only.
yes.
Apropos that consideration, there should be some part payment.
Yes, and that part payment, my lord, we had
1 rupee British coin.
no. 15 lakhs was the consideration amount. Out of that, my lord, 3 lakhs odd was paid.
Yeah.
Yes, kindly takes my plaint case. Kindly takes the
Document.
yes, kindly takes the plaint.
This is what we really wanted.
My lord, kindly takes the plaint at page. My lord, the plaint, my lord, we had handed over on the.
Yeah.
Not have a copy of the plaint.
My lord, kindly takes.
I have a copy of the.
No, how will I, my lord, have it? He has not given. a
My lord, I'm
copy.
good.
Yeah.
My lord will take it up at after recess. Yes,
We continue.
my lord.
85, my lord. Your lordship has been paid to dismiss for default, my lord. Let this. Immediately thereafter, my lord, I came, my lord. My lord, at that time, your lordship was not here.
No other side appeared. Call him.
Ismail, I am calling him. Great, my lord.
Your lordship would kindly take my first the plaint case once. My lord, internal page 2 of the plaint, paragraph 5 onwards. Be it mentioned, my lord has found. Be it mentioned here that at the time of raising of the said building, said Shukesh Chandra Sengupta was struggling financially and thus approached the plaintiff for monetary assistance. The said Shukesh Chandra Sengupta approached several other individuals and obtained several loans to be able to construct the said building on the said premises. The plaintiff in the year 1980 and on different dates gave rupees 3,80,000 in total as loan to the said Shukesh Chandra Sengupta, as the plaintiff had assured that the same will be returned within a reasonable period of time. It is pertinent to mention that the entire transaction was based on trust and understanding, because of which the plaintiff agreed to provide loan to the said Shukesh Chandra Sengupta without any documentation. However, the said Shukesh Chandra Sengupta failed to return the loan amount within the considerable period of time. Instead, the parties entered into an oral agreement dated April 16, 1981, wherein it was agreed that the said Shukesh Chandra Sengupta would sell the said premises situated at such and such in favor of the plaintiff for a consideration amount not exceeding rupees 15 lakhs only. The said amount of rupees 15 lakhs was the then market price. The necessary documentation, it was agreed, would be executed as and when the lesser, that is the state of West Bengal, such permission, state grants such permission as and when the embargo on transfer of the properties would be lifted. It is pertinent to mention that such an oral agreement was made in presence of the defendant number 1, that is Rina De, and that the said defendant is well aware of such agreement. This is the consideration and the agreement that was witnessed by the defendant number 1. Now, your lordship would kindly take the pain of looking at page 20 and 21 of my stay application. Injunction application, I stand corrected. Your lordship would
injunction application where, my lord, I issue a letter to the defendant seeking specific performance of the contract. Now kindly takes page 21, second paragraph. Sukesh unfortunately passed away before the notification permitting transfer of Salt Lake properties, including the said property, was issued. At the time of death, you had been residing with Sukesh. After that, you disclosed that Sukesh has died. After publishing a will and after grant of probate, you will honor the agreement for Sukesh. On several occasions, you told me that the probate has yet not been granted. But recently on 15/12/2023, I have come to know that the probate has been granted long back. But in spite of meeting on several times, you did not disclose the same to me. Thereafter, my lord, so far as the consideration, in view of the increase of price of property, I am ready to waive the amount of loan, that is the rupees 3,80,000 to Sukesh, and I am ready to pay the settled amount of rupees 15 lakhs. Now, in response to that letter, whereby she has agreed to the agreement, agreed to the consideration amount, and her only grievance is that that 15 lakhs should be enhanced. Now, I have taken instructions from my client to show my bona fide, I am ready with that 15 lakhs. Yes. Willingness, but I'm ready with that. Yes, yes. And my lord, the probate has been
That she's ready.
No,
Yeah, absolutely negated and denied that there was money tender, there was no payment, nothing of that.
no, your lordship would kindly read from the page 22 once, my lord, may I just please.
I have read that letter written by her at page 18 of the paper.
No, kindly takes page 22, my lord, of the injunction application, my lord. Letter dated 16th of January 2024. Yes, my lord, the third paragraph. I am also aware of the fact sometimes in the year 1981, you and my brother had entered into an agreement.
There, no difficulty. He has also said that.
And the consideration was of rupees 15 lakhs.
He admitted that yes, my brother, which I informed that he applied for transfer.
Applied for transfer and there was an agreement and the consideration was also rupees 15 lakhs. Kindly takes, my lord.
No, that is what she.
Yes. So, my lord, there was a concluded contract. The learned trial court, while rejecting, has come to a erroneous finding that there is no concluded contract. And my lord, I'm to show my bona fide, my lord, I'm ready with that 15 lakhs.
I appear only for the respondent number 2 in this proceedings. Lord, that is Devashish Sengupta. Lord, this entire plaint and the entire cause of action, Lord, which has been projected before the trial court as well as before this lordship, is absolutely act of fraud.
Fraud.
Yes, I tell your lordship, my lord, I had indicated to Mr. Banerjee before the matter was taken up, Lord, whether he was properly instructed by his clients, because since I know him, Lord, I own this property. I am a 50% owner of this property, that is Devashish Sengupta, the ground floor, by virtue of a registered gift deed, which was executed in the year 1982. Now, Lord, kindly appreciates his plaint case.
Who executed?
My uncle Sukesh Chandra Sengupta, against whom, my lord, he is trying to enforce, the original person against whom he says that he has entered into an oral agreement. So, my lord, he had executed 2 documents. One, yes, my lord, I shall file with all the documents. And, my lord, there are other proceedings pending against this same property, not in other courts. My lord, I'll show that. My lord, I'll completely demonstrate. My lord, this is, my lord, this is a.
Who has filed other proceedings?
My lord, it has been filed by Rajiv Kumar, one of the persons. I'll show, my lord. There is a nexus between this Ganesh Day and Rajesh Kumar.
Whatever you find your right.
Yes, my lord.
After hearing the counsel, the respective counsel, that an opportunity should be. 51 agreement, 24 suit, whatever. Yes, next.
Lord, I am for the appellant, my lord.
I am for the respondent in this matter.
My lord, if your lordship.
Sit down.
Lord, I beg to appear for the appellant, my lord. Mr. Dhananjay Banerjee was leading.
Tribunal
Yes, my lord. Mr.
of the custody.
Yes, my lord. Yes.
My lord, I beg to be excused, my lord. I mentioned this matter. Your lordship directed me to call the other side. At a number 285, my lord. Other side is here, my lord. Let this be restored, my lord.
Restored.
Grateful, my lord. 285. At a number 285.
On the ground of this pendency of this application, they are taking series of adjournments, my lord.
No, my lord. There, yes, everything is going on there. কোনটা adjournment আছে? চলছে তো prosecution হচ্ছে তো grateful man.
I appear on behalf of the respondent defendants.
And this is the evidence service. So service. 1 to 17, my lord. Instructed all are been served. Introduced the advocate who was representing the opposite parties with the learned trial. দেখেছিস তো সার্ভিস হয়েছে তো
Yes.
The defendant number 6
How many respondents are there?
17 1 to 17 are the plaintiffs opposite parties. Rest of the opposite parties defendant. Defendant number 16 is the appellant before your lordship.
How this order is applicable?
Injunction.
Order under challenge is
Well,
8th December.
8 December 23 is the order.
15 December.
No, 8 December 2023. Order number 2. I got it. Now I'll turn to the plaint itself once. Page 33 of my application for stay. Paragraph 2, my lord, can you consider paragraph 2 of the plaint? That thereafter the said Muhammad Sheikh died leaving behind his 4 sons, such and such, one daughter, namely such and such, extent of 1/5 share each. Thereafter the first, second, and third son.
Under the Mohammedan law, one the daughter will get half the share of the son.
Must be double, the son will get.
That's why half the share of the son.
It is their plaint, my lord. I'm relying upon them. Now, my lord, what the interesting question will come up after that, my lord. We needed the share respectively as they were in exclusive joint possession of the A schedule property. Moreover, during the LR operation, CSR's DAG number 586 was fragmented and broken into 3 separate LR DAG numbers: 585, 586, and 587. So it is admitted that the 3 DAGs are there. Now, my lord, can you turn to page paragraph 3? That thereafter the predecessor of the defendant number 1 to 14, namely Abdul Sattar, transferred 10 shadaks of A schedule property to the defendant number 15 by virtue of registered deed of sale being numbered such as 1980 for the year 1998 by exceeding its limit and that the said defendant number 15 transfer the said 10 shatas of land to defendant number 16 by virtue of a registered deed. So this is the transfer which was admitted. Now, my lord, can you turn to next, my lord, paragraph 4.
You want a defendant number?
16. Now, my lord, can you turn to next? Now, paragraph 4. The defendant number 16, 18 conjointly with a view to grab the entire A schedule property are trying to erect the shed along with the entire A schedule property by illegally and forcibly trying to grab the entire schedule property on the basis of the illegal transfer, and seeing such illegal activities, the plaintiff raised vehement objection and requested themselves to refrain from doing such illegal activities. But the defendants are so dangerous, powerful, and moneyed person, they are forcefully trying to grab the entire A schedule property by depriving the legitimate claim of the plaintiff. So it is become impossible plaintiff to continue the joint possession of the defendant in respect of the A schedule property, as a result on which the plaintiff requested defendant to making amicable partition. So, my lord, the
Paragraph 5, first line.
yes, the previous, so it is entirely A schedule property.
Number 16 or a defendant number 16?
No, the defendant, it should be defendant number 16.
Plaintiff, my lord, therein.
They are in plaintiff, here, my lord, the defendant number 16. The defendant number 16.
File a suit.
Yes, file a suit. Declaration and injunction against some of my client.
What ex parte degree?
Degree.
Appeal is pending.
Appeal is pending. Now, my lord,
Appeal has been admitted, my lord. Appeal has been admitted.
Any stay order has been passed.
Page 14, my lord, the plaint. I've annexed. They have admitted. Nothing.
Stay order has been passed.
My lord, I'm told that appeal has been admitted.
This is not a debate which is going on. He is an appellant. He has a right to make submission first.
Now, my lord, can you turn to page 14, my plaint.
Yes.
The some of the plaintiffs were added as defendant in the said suit, and my lord, can you turn to the schedule, page 17. 10 decibel, particularly LR Dag number 587, which was carved out pursuant to that transfer. It was carved out and LR separate Dag number has been allotted to 587. And in this 587, my lord, the degree was granted. Yes, I am an exclusive position, 16 share, and also restricting the defendant from interfering with my position. Now they want that A schedule property by including the CS.
Some of the plaintiffs are those defendants.
Yes, yes. They have also admitted in that plaint also. Now, my lord, now I am relying on my lord's judgment, which my lord representative of the estate. Oh, Krishna, so my lord, that is some of the estate of the person was there, my lord, there. Some of the defendants were there, and it was quite represented, unless there is a fraud or collision is there. So they cannot shirk their responsibility by saying that some of the I am not the party to the proceeding. So it cannot be binding upon me at all. There is no challenge to that effect, my lord. They have challenged with these deeds as well. No, those deeds are not binding upon. If those deeds are not binding upon, then, my lord, they have admitted that execution has been there. If the execution is there, my lord, they cannot come to be a void deed. Because the prayer itself, my lord, will find the prayer made regarding for the deeds are concerned, those are manufactured. B. For degree of declaration, the deeds of sale in the name of defendant number 15, 16, and 17 being numbered 1980 for the year such and such. All are relevant transfer related to DAG number 585, 586, 587. All are forged, manufactured, illegal. They have admitted the execution. This is one of the years transfer of the property. This is 10 decibel of land. That be so, then how it can be termed to be a forged and manufactured document? Yes, all are plaintiffs of the shares of my lord. Shares of Muhammad Sheikh. Yes, Abdul Sattar.
One of our questions.
Oh, one of the questions, the years are also there. They have also there. Yes, yes. Yes. That your lordship will find. Years of Musha, my lord, was the defendant in my suit. Years of Musha. Yes, Sheikh Musha.
that
Oh,
They-
sir.
yes,
Musa was another son.
yes,
Oh, yes, Muhammad Musa was there.
yes,
They were the heirs of Musa.
yes. One of the son was made party in my suit.
Three defendants. One other.
Others are the son of Brother Sekiasi, Islam. His wife was made party. That the plaintiff number 17, my lord, will find. Plaintiff number 17 in this suit. Habiba Begum, wife of Sheikh Islam. But their sons are disturbing us. We filed a suit against them. But here, my lord, I find that their mother was made party by excluding the sons. I do not know why. What is the reason? Apart from, my lord, kindly consider the photograph showing that my exclusive possession of the plotted land, page 29.
You are making a construction.
Page 29, my lord. This is the, because they have a warehouse, we have to construct a warehouse over there. So this is the foundation is going on by encircling by raising boundary wall. And we are related only particular to that plot which is 10 decimal of land. That is LR plot number 857. The 587. 587. And we have purchased this from Bhagwan Das Agarwal, who have purchased prior to us from the original owner. And the property was purchased by Agarwal in the year 1998, from whom we have purchased. After purchasing the plot, that portion, he mutated his name, separate Bata plot, this plot was created at the time of LR, and that plot was transferred entirely to us, this company.
LR operation of
After LR operation, this plot of land was carved out from the original RS.
what the LR record says, 587 in
No, subject to correction only, it is Bhagwan Das. LR record of rights আছে না আমার কাছে নেই. Not been annexed, মানে it is not with me at present. তোর কাছে আছে কি? না, annex এমনি কোনো copy আছে কি? No, that copy is not with me. But this 10 decimal of land is the entire 857. This 10 decimal of land is the LR DAG number 857. 587.
comprised of
10 decimals. So that
standing in whose name?
and that বিষ্ণুপদ আগরওয়ালের নামে হয়েছিল কিনা সেটা এলার
No, no, even prior to Agarwal.
Yes, it is in the name of the Abdul Sattar. 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 সেটা তার আগে admitted. There is no dispute about the same. Because the entire plot or stretch of land has been transferred in various deeds to various persons. That is the industrial belt, my lord knows. Now the construction, as soon as the construction started regarding the Pondicherry, they came forward and with this, some other means due to some other reasons, my lord. The learned trial court, without considering the same, my lord, from their own document it appears. What this services, the learned trial plenty on going through the materials on record, it appears to me, privacy plenty has interest over the suit property which is required to be protected. Otherwise, the object of injunction will be.
The plots they may have. But
I have no objections over the other plots are concerned. On the very first day, my
586, no problem.
no problem. Whatever the I am only 586. Which was executed, even not paid for cancellation. Being the predecessor, my lord, they are the executed can be considered because their predecessor executed the deed. Admittedly, they have admitted that deed was executed. They are the heirs of the original executed. So unless until there is a prayer for cancellation, whether the suit for partition is maintainable when the execution is admitted. No, no. 10 decimal lines. Again, 587. এই না না এটা আর এস দাগ নাম্বার 586 এলা দাগ 586 করে দিচ্ছিস
Yes. My lord, the fact remains that the property is unpartitioned. My lord, only two modes of partition are recognized under section 14. One is my lord,
by virtue of a decree or by virtue of
partition.
amicable partition.
My lord, kindly come take up the plaint, my lord. Once, page 14.
It appears
Page
from paragraph 2 that the parties may, that is implied that the parties may have divided and that was fragmented during the LR operation. And LR operation came after the West Bengal Land Reforms Act came into force. It was a matter of 1955 onwards. What you were doing, and then say that these entries are erroneous.
My lord,
You are paid for declaration as well.
subject to correction, entry
No,
does not
okay,
create or diminish right, my lord.
We will permit them not to construct. You deposit certain amount as a security deposits. That in the event if you cannot prove your right in respect of 587, then at least the compensation they must get it.
My lord, kindly take up.
Bring those line of judgments of the Supreme
Yes.
Court at the time of justice.
Justice Sinha.
My lord, kindly take one point into consideration. My lord, kindly take up the title suit, page 14, my lord. Page 14, paragraph number 2.
Yes.
My lord, that the plaintiff further submits that the suit property was owned and possessed by Vishnu Kumar Agarwal, Bhagwan Das Agarwal.
Talked about what has happened prior to him.
My lord, he was aware that there was a knowledge, my lord, who has purchased the demarcated property of Sheikh Abdul Sattar, my lord.
That
My
is
lord,
what these are to be read along with your statement.
my lord,
Your statement in paragraph 2 is in your place that yes, this property originally belonged to some certain persons.
yes, sir.
These four sons, one daughter, and they were having this. And then you said that how this plaintiff inherited from them. And then you said that during LR operation, it was fragmented 3 parts. 585, 586, and 587. Now, you yourself have said that a different tag numbers have been given. Now, you did not challenge that. That how can you separate the tag number? It's a separation of a plot.
Share remains
Now-
intact, my lord.
No, sir.
Subject to
Now,
correction, my
now
lord.
it appears that 587 has been sold by Abdul Sattar. You said that Abdul Sattar has sold in excess of his share. That he has to be considered at this stage you can't. At this stage you can't.
My lord, in the previous
Because I find he sold actually 32 decibel. Because he also sold 22
16.
To defendant number 17.
17.
My lord, kindly take one aspect into consideration, my lord. My lord,
Bring that.
my lord, my lord, one.
Bring it tomorrow.
Yes.
My lord, kindly take up one fact into consideration, my lord. My lord, kindly sees the previous suit, my lord. In the year 2023, my lord, without adding other kosher as a party, my lord, kindly take up the judgment and decree within 6 months, my lord. Judgment has been we did not have the breathing time, my lord. My lord,
Are you arguing a writ petition or a civil suit? Civil suit.
Order 9 Rule 30 not filed.
Irony of the bar is when a suit is expedited, they have a problem. When the suit is delayed, they have a problem. You will say how the court is granting 4 months, with 5 months gap, the adjournment or the dates, up to have disposed of the matter. You have a problem.
I was not.
When he is expediting, when he is proceeding, say in a good tune, you have a problem. Oh, within 6 months the suit is decreed. How can it be? It should take 6 years to.
I'm not opposing the performance of the learned judge, my lord, subject to correction, my lord. I'm just
sorry. The decree is still operative. The decree is still binding unless set aside by an appellate court. We are preferring an appeal does not mean that the efficacy or a binding nature of the decree gets effaced.
Order 9 Rule 30 not filed.
Sorry. You can't see. If some of the plaintiffs who were the defendants there have joined together, look at the consequences there. The construction has started. They are doing. You are stalling. We will say section 14, but you deposit certain amount.
My lord, our case is that we are in possession.
So one thing,
I'll bring those.
I suffered that order in one of the matter. Kalita Sadhu, PIR 2005 Calcutta.
And after that,
And also the do it.
And also on my lord says Bhaskar is sitting in division bench. My lord says, yes, I'll allow to sell out the property, but you have to secure the interest of the plaintiff also.
That is a different case.
No,
where the construction has come up.
here also, my lord, I have purchased.
Because the same stuff.
No, this is warehouse. My lord, after that, it will be the tin shaded. After that, no. There is no question of any.
Told that land is lying vacant, man. I'm told that. I have instruction, man. I'll come back tomorrow.
Then we are appointing a special officer to go and submit a report to us.
I'll come back. Permit me to come back tomorrow.
Tomorrow, come back.
তুই ছেড়ে দিচ্ছিস যে সবচেয়ে বড় দামে কিনিস রে বাবা
Used to appear with you in the state matter, the other side, in the previous matter. Here's the mindset. State always delays the matter. Actually, he has the same mindset. State is decreed in 6 months. Imagine probable.
That is, you can't hold efficiency as a. Ironic that I'm making this submission with this matter now being called on. I am before your lordship, my lord, against an appeal.
The hearing is to be expedited, orders have been passed.
I'll tell you, lordship, no, my lord, I was to secure the entire decretal amount.
Stay application.
Yes.
Section 5 has been
Section
allowed.
5 allowed. I was to secure the amount and the execution was stayed. This order
Time frame.
within 4 weeks.
Did you
This order was, I'll be candid and honest.
carry out?
No, not
No.
carried out because your lordship kindly sees they are not appearing in the execution proceeding and
By the court will
and
wait.
and the date is for awaiting order from honorable court for stay. That is the order.
If the stay was a conditional one,
I am not, no, I am willing to pay.
It's first court, my lord. Additional district judge.
Additional district judge.
The
First court, Alipur.
the
Lord, may
presiding
I
officer is on leave. Your lordship kindly sees the order dated 23rd of February 2024.
and when the stay was granted,
Stay was
Stay was-
granted in August 2022. The deposit has to be made.
But this matter has,
communicate that they have not complied with the order.
Yes, and we were proceeding. We were proceeding. We have filed our hajiras, but your lordship kindly turns over we have given the stay status. All the orders are not there in the server, my lord. Since May 2023, it is for awaiting order from the higher court. Because we have given, and now whether it has been deposited or not, these things are being sought to be clarified. These were
I was beseeching, I will not waste too much of your lordship's time. It's not my nature to say. There have been delay. There are reasons. But my lord, I also cannot justify the reasons why I have not come so long. But I am ready to will. Your lordship gives me 3 days time, I shall deposit. Or tomorrow I shall deposit. See, this is the application. Can 4. Can 3 I would be praying for withdrawal. Can 4 is the application this is the application. So your lordship comes to page 14. That is the division bench order. First is the limited section 5, and there are page 15.
That decretal amount
Entire 3 matters are there.
from date.
Yes.
This order was dated
5th of August.
August.
25th of August 2022.
4 weeks take us to 1 month practically. So September 2022. Now we are September 2023, 1 year. And then another 6 months.
More than 6 months.
More than 6 months. So 1.5 years. What is the explanation?
No, the explanation is first, there was a delay in sanctioning of the amount. That the second part.
Should expect. How much delay one should expect?
No, I am the last person to come and tell your lordship even. But this is the matter where unfortunately
10,000 deposited.
Yes, that is deposited.
That was immediate.
that was given. Fortunately, my luck somewhere that at least that was given.
Thank you.
Yes.
Immediately.
The 3 matters, 30,000. That went through. This was about 80, when the 3 matters put together is about 83 lakhs. The all the matter 84 lakhs.
What?
No, that's the amount which took time.
The thing, you have acquired the property, you are using it, utilizing it, and enjoying the usufruct therefrom. You will not pay.
That's as today I'm before your lordship in a matter where I can't stand and try to justify anything. Lord, I was beseeching your lordship's kindness, but we are willing to do it. Your lordship give the shortest time.
What is the internal difficulty of the government?
Lord, getting this matter from the
paragraph 14. Why you were waiting? You should have come in the month of September itself.
No, my lord, I'll tell you, lordship, if my lord kindly comes to paragraph 8 and 9, I don't want to say it in open court, my lord. there was some delay on our portion. The file was kept with a lawyer, and I don't want to take those things for some time. But that is only after 1 year.
They're all after. What has happened after this order within September? What is
No, nothing.
nothing? Then
That time, my lord, getting the funds, my lord, that took us some time. Getting the funds for the board was taking the funds.
everything was over. Normalcy has increased.
No, getting the funds.
What funds?
Because this is 84 lakhs of rupees. Getting this, we had to have a sanction, allocation, these things.
After immediately after August, there was a 2022 celebration of Durga Puja was also there in October.
Must have been. I know what your lordship is getting towards. I've understood it. These are questions which I cannot answer to your lordship. Your lordship cannot put the question to me in open court. I cannot answer to your lordship in open court. I've understood what your lordship was trying to say, and I really don't have any answer. May I say this, my lord? I was wishing your lordship gives me the shortest time, and your lordship puts me on terms. He's secured.
The
part will also go up.
The difficulty is, your lordship, the decree was passed in 2016. Now, every time it is the state who is taking their sweet will and they are filing the appeal. They are
Be realistic with this. Suppose we deny. There's no deposit. You have to proceed with the execution. Or you will realize there are there will be damage because of for sale of that public property.
I get it.
Realization. We don't know how much time it will take.
Only thing I am praying before your lordship, let the appeals be heard of.
No. Obviously, he's entitled to make that.
As far as this part is concerned, I think the money should come from their end. And the next day, you know what is.
So it's come to the registrar. Order says registrar.
What will happen?
The lordship has seen how the execution case is proceeding, how they are appearing, how they are now.
No.
Once this disputal amount is deposited, nobody will take any steps with regard to the proceeding of this. And my client, my lord, is 85 years old. It is only the wife who is taking.
As a excited advisory, you should know that after the deposit, what is the next course of action?
Be beseeching your lordship that since so much time has elapsed,
interest is boundary.
But only the decretal amount.
Higher rate.
Only
when they rate for fixed deposit.
That is being challenged. The rate and the amount. Only 6 lakhs.
Amount. It's total about 84, near about 84 lakhs of rupees total.
This is 6 lakhs per katha has been adjudicated. They are challenging that in a Lake Gardens area property. So
6 lakhs.
that has been awarded and that they are challenging. That they are challenging.
Subjection.
No, we have not taken any steps. We have accepted that. We are happy with that, but they are not.
Why you are raising this?
From 2016, it is going on. There was a delay of 904 days.
I will not bargain. No, I will not bargain with the court. My conduct is such I cannot. There's some I own a duty to the court. But only thing I would say is your lordship will not make it too enormous. Last time your lordship will kindly not. Your lordship will kindly not do this. I'm putting in. Well, I'm not doing any favor.
Facts, not a issue. On the last of this, ask the Advocate General to answer and the additional government to answer. And is there any litigation policy adopted by the state government? Whether where there is a litigation policy. Litigation policy.
Around 2011, many states adopted a litigation policy.
And that's a very unique and very, I would say, enterprising.
I have no idea whether if your lordship that is
the litigation policy that which I gather is that suppose a point has been argued by you and that point has been decided finally, Supreme Court or whatever, at what level, it has come to an end. Now, every litigation you will not be permitted to take that unnecessarily wastage of the court's time. When the court, the point has already been settled and decided. So the state has decided not to pursue the matter on that ground.
I wish there was such a policy.
That's a very unique. That's
absolutely. I bow down to your lordship. I really believe. I'll tell you, lordship. Now that your lordship says it, I think it's a very unique thing, and it would be a very helpful. Because in a lot of matters, what happens is we get note sheets for filing appeals. I look at the matter where it is well settled proposition, but nobody wants to take the tough decision of saying it won't prefer an appeal. So if the department sends it to the LR, the LR also said, why should I take a tough call? Okay, as per demand and preference. So unnecessarily not only, in one matter, I distinctly remember the quantum of money that was to be paid was 75,000 rupees. My first question is that for filing this appeal, for the counsel's fees that you are going to spend, are you not going to spend more than 75,000 rupees? Why are we filing this appeal? I was told yours is to file, fine. And in that matter actually went on for quite a while, then dismissed, and the council, the litigation, state's litigation cost was more than 75,000. I bow down, and I fully appreciate what your lordship is saying.
Whether like this, that there must be a particular parameter with this that absolutely stays, like in the income tax. There are many.
No appeal should be preferred.
Can say that up to this amount of money, the department will not prefer an appeal. Accept it.
Very these are. I'm telling you, lordship, my own experience.
75,000 state will not oppose.
75, and the litigation cost was more. My appeal, filing of the appeal, my junior's brief, my Xerox, photocopy, and everything put together was more than 75,000 rupees. For what it was an appeal preferred.
Think of you are a senior advocate in the government panel, senior standing counsel, then you should.
No, I'm grateful to Lakshman. I will try and find out.
As your lordship.
Right. Well, while condoning the section 5, the division bench has said that irreparable loss would be suffered. Can I suggest, it's for your lordship, the irreparable loss would be say if the appeal is not allowed, not heard. This was the language. Prejudice to the appellate.
The usual order which is passed while allowing a section 5 application.
No, I am not on that. Your lordship asked what is the if I can borrow this expression, up to your lordships. Places the money is secured with the registrar. I'm not trying to make that as a ground.
Extending the time for a period.
No, I'm not.
For deposit of.
I bow down to your lordship. I don't have a.
Okay.
But that's why I'm only saying that instead of 1 week could be 2 weeks.
Then both has to be done as 2 weeks.
It's both will have 2 weeks. 2 weeks instead of 1 week.
You will get an interest. You are a beneficiary. Because the fixed deposit may carry an interest of 7.5%. Where in that, under that sections, 12% and 15%. So development.
Till I am not getting it, my client is not.
And thereafter,
The interest will be
You know what
calculated
is
on the
required.
date of deposit. মানে এই T3 কিন্তু স্যাংশন হয়েছে তার বেশি হয়ে যাবে
2 বছরের 2 বছরের 2 weeks we have to do.
The last line of your lordship is lethal. That's all I can say. I was just trying to sit and calculate
2016.
that
When the decree was passed, it was
the
calculated
last
up to
line has been a lethal line. I'm not for a moment. As I said, I'm not. I তাহলে দরকার নেই ছেড়ে দাও ঠ্যাংড়ামো হচ্ছে ক্যাম্পিং 2 বছর পরেইছে বলবে রাতারাতি স্যাংশন করতে বলবে I mean, one more thing about is that there is one can 3. The lordship will give me liberty to withdraw that.
The counsel for the senior matters you are appearing in. Order. Now your client of 85 years of age, something. The
He's
amount,
bedridden
I just
by
made the mental calculation, the amount jumps tremendously.
Everything is being done by his wife. Everything is being done by his wife. He is bedridden, he cannot even speak. He's in a paralysis.
It will give some kind of
Maybe I do.
assistance.
Maybe I do.
Down for the petition.
Lordship, in this matter, my lord, the plaintiff is the appellant before your lordship. And lordship will remember, in this matter, the commissioner, my lord, partition suit, learned partition commissioner, my lord, has allotted the entire property in favor of the defendants. And the plaintiff has been provided with the wealthy money. Last occasion, lordships, my lord, it fell from your lordships that whether the section 2 and section 3 of the Partition Act is applicable.
Well, it has to be done. If it is not portable, then
My lord,
it is a duty of the court to auction it.
my lord, I have gone through it, and Mr. Shivashi Ghosh was also, my lordship requested him to find out. Lordship, lord, what fell from your lordship from the bench is that the section begins that whenever in any suit for partition in which, if instituted prior to the commencement of this act, and lordship said it whether it has to be read even if instituted after commencement of the act, whether it was like that also. But after reading the entire section, lordship, it appears that in that the court, my lord, may I read it out? Whenever in any suit for partition in which, if instituted prior to the commencement of this act, a decree for partition might have been made, it appears to the court that by reason of the nature of the property to which the suit relates, or of the number of the shareholders therein, or of any other special circumstance, a division of the property cannot reasonably or conveniently be made, and that a sale of the property and distribution of the proceeds would be more beneficial for all shareholders, the court may, if it thinks fit, on the request of any shareholder interested individually or collectively to the extent of one moiety or upward, direct a sale of the property and distribution of the proceeds. But what was bothering here is that on the request of any such shareholder.
The duty of the court to really ask for that.
Ask for.
Holding that it is not portable. And the moment the court declares that it is not portable, then the parties, any of the parties may make a request that I am ready to buy the shares of the.
Unless I know that it is not portable, so I cannot exercise my right.
Commencement. I was of the impression, I just wanted you to go through that why this right is restricted to a suit for partition right before commencement of the. If the spirit is that if it is not portable, then in that event it has to be adjusted in this fashion. Even after coming in force of the act, there may be the property of the situation like this. It can we not extend?
Lordship, what lordships were saying that even if maybe it was at the intention of the legislature, that even if it is instituted before the commencement of this proceeding.
Thinking in that line, whether this can be. Now you have done what do you want actually in this application? We are not have you served the copy?
My lord, we intended to serve, but it was returned and the publication was made. And affidavit of service to that effect has been filed.
Against the final degree.
My lord.
Execution has been defined.
Execution, what is it? Execution final is it?
Because the royalty money and then the registration has to be done.
Registration has not been done. It has not been engrossed yet.
They have it filed in the execution.
No, my lord. None of the parties have put it in execution.
Otherwise, we would have directed the lawyer to be served.
Well, that was done. Lordship was of the view that whether it has been engrossed or not. So we had taken instruction, and he also refused to take. My lord, service of the application. Thereafter, lordships were directed me to publish it. It was published, and section 5 was allowed.
Now, what do you want?
But in present application is for an order of injunction.
Of raising construction.
My lord, and alienating. Raising construction and alienating the property.
Not raising any construction, alienation we are stopped. We say since it has come to him exclusively, so he may not deal with the property.
My lord.
Where is the publication? Have you filed the affidavit?
Yes, Lord. My lord, I have filed. After it was filed, a section 5 was allowed, application. একটা copy আমাকে দাও।
Yes. So the appellant, pursuant to your lordship's earlier order, Madam. 302. Partition suit or probate? Partition suit. Partition suit. I'm not. Today I just complying the order before your lordship. Pursuant to your lordship's earlier order, Madam. The fine of rupees 5,000 was paid. 5,000 rupees for cost has been given. Right, Madam. I paid. And affidavit in reply as what copy? Affidavit in reply. Yes. Come in. সই করে দেবেন না? Today, Mr. Mohinder Gupta is absent. That is why I'm just, one thing also I'm submitting, my lord. That pursuant to the the, yes, my lord, today I also want to submit the supplementary affidavit on behalf of the appellant, my lord.
For what?
Lord, there is so many questions. Unrelated. Thereafter, I want to supplementary.
Next day we'll consider.
Lord, kindly add one line, my lord.
On the next day we'll consider.
এটা কি রাখবেন? এটা কি সাপ্লিমেন্টারি? এটা কি সাপ্লিমেন্টারি? স্যার এটা কোথায় ভুল হলো?
See to it. It's a direction. Will come, don't worry. You are not interested in the application.
এখানে 2 নম্বর 302
The thing is there.